Hi there, and welcome to Winning with Patents, a practical guide for startup innovators looking to turn intellectual property into a true business asset. I'm Jackie Hutter, and I've spent the last 30 years working with companies of all sizes, from solo inventors and early-stage startups to global enterprises, helping them build patent portfolios that actually support business growth. What I've learned is this: the most valuable patents are not just technically sound, they're strategically aligned with how the company creates and captures value. And that's exactly what we're going to explore today. Whether you're just getting your product off the ground or gearing up for investor meetings, the right patent strategy can make a huge difference in your company's ability to succeed in today's challenging startup environment.
Let's start with how patents can help you create sustainable revenue streams. Of course, your patents can cover products and technology that you are selling to customers, and if your patents are well crafted, you may be able to generate premium profits. But patents can open up other options for generating ongoing revenue. When you control a key technology, you can let others use it under license, creating new income channels without additional overhead. Consider my startup client that developed an innovative way to measure a patient for a medical garment. An established medical garment manufacturer obtained a license from my client for their methodology. My client was able to fund ongoing company needs, specifically its long-term innovation roadmap development, using the licensing revenue received from this manufacturer that sought innovative ideas like those of my client to increase sales of its existing product lines. And this funding was non-dilutive capital. Next, strong patent coverage can demonstrate a viable business strategy to investors. Patents aren't just legal assets, they're signals. When investors see that you've protected your core tech, it shows you're thinking long-term. You're protecting value, not just creating it. Especially in deep tech or hardware, IP can be the deciding factor between a seed round and a pass. Consider a startup working on ammonia-based fuel cells. Their patent strategy showed that even if their first market didn't pan out, the tech could still be monetized elsewhere. That optionality gave investors confidence that the startup's management team was less likely to fail, even though they might have bet wrong in a first market validation attempt. Patent protection can also underpin strategic partnerships. When you're negotiating with a larger company, maybe a manufacturer, distributor, or corporate partner, your IP can be what brings them to the table. It can signal to them, we have something unique, and you can't just build it in-house without us. For example, a wellness startup with a patented relaxation device landed major partnerships largely because their core technology was protected and couldn't be legally copied by competitors. Patents give you leverage in these types of conversation. No IP, no leverage. And finally, patents can enhance your exit value. When it comes time to exit, whether it's via acquisition, merger, or IPO, buyers aren't just looking at your customers. They're looking at the defensibility of your product or technology. A startup that filed patents around precision agricultural spraying using computer vision was eventually acquired by a major machinery company for several $100 million. For the acquirer, the startup's well-crafted patent portfolio made the acquisition not just strategic, but a necessary component of their innovation platform.
Let's break down what a U.S. utility patent actually protects and what you need to get one. First, patents are only granted for inventions that are both new and non-obvious. That means your invention can't already be out there in some form, and it can't be an obvious variation of something that is. Utility patents cover three main categories: compositions, like chemical formulas or material blends; products, physical inventions like tools, devices, or machines; and processes, systems or methods, as long as they meet the statutory requirements. Now, for an invention to be patentable, the examiner looks at two things. One, prior art, that's anything already known or published that's similar to your invention. And two, whether your patent application includes enough detail to explain exactly how the invention works. Here's something important. A patent doesn't give you the right to do something with the claimed invention. This means that you can obtain a patent to your company's technology or product and still not have the right to legally sell it because you may infringe another company's patent. Instead, your patent gives you the right to exclude others from doing something with the invention set out in your patent's claims without your permission. This right to exclude includes the option of preventing other companies from making, using, selling, offering to sell, or importing the patented invention. And one final reminder. U.S. patents only protect you in the United States. If you want protection elsewhere, you'll need to file in those specific countries. Here's something I want every founder to remember. Startup innovators have a special relationship with patentability. Why? Because startups aren't just making things, they're solving big problems to move things forward. And that's exactly what the patent system was designed to reward. Now, here's the good news that might surprise you. Most startup company innovations can likely be patented, as long as your application and claims are crafted the right way. If your product or technology solves a customer problem in a way that hasn't been done before, that makes it novel. If that problem is meaningful and your solution isn't obvious to others in your industry, then it's also non-obvious. That's the core of patentability. Take the example of a startup that created a discrete home delivery system for women's reproductive health products. It's not that the products themselves were new, but the company's logistics model, customer interface, and privacy mechanisms created a brand new way of solving an old problem. Their IP focused on that beneficial functionality that consumers needed and were willing to pay for, and this new and non-obvious take on a long-standing problem was patentable. So instead of asking, "Is this patentable?" ask, "How can we describe our company's innovation so it qualifies for patent protection?" Let's talk about platform innovations. These are often the crown jewels of a startup's intellectual property portfolio. Unlike a single product, a platform is a foundation. It's a system or method that can enable many products, services, or business models. Because of this, platform innovations are typically part of a broader IP strategy. The goal isn't just to protect a single use case, it's to protect the core functionality across as many future applications as possible. But to do that, your patent filing needs to go deep. It has to include extensive disclosure, details, use cases, variations, and examples. This allows your claims to be broad and gives you the flexibility to file additional patents later using the disclosure of the same foundational application. Here's a key strategic move to creating platform process patent protection. If you're building a platform process innovation, don't just file narrow claims on your first use case. Capture the full scope of what your technology enables. Ask yourself, how will the world change once customers no longer have this problem? What new opportunities emerge when this innovation is adopted at scale? How might customers behave differently when this becomes part of their workflow or lifestyle? Notably, platform process innovation patents are often filed years before market introduction of the full suite of products or technology. This means that you have to spend the time to analyze what the future might look like if you made the right technology bet, even when the future is far off. By looking at what might change once the market evolves, you can future-proof the value your platform delivers, not just today, but years down the road. Now let's shift focus from platforms to product innovations. When your startup is centered around a single product, like a physical device, a digital tool, or a unique material, your patent strategy needs to be more focused, but no less strategic. Product patents often target a specific solution, which means you need a deep understanding of the prior art, what's already out there, and how your product is different. That difference, how and why it's better, needs to be clearly explained in your patent application. And it can be very useful to describe in the application where other products fall short so that the examiner can understand why the invention in your claims is, in fact, different from the prior art he or she sees every day. You also need to think ahead. If a competitor wanted to copy your product, what small changes could they make to design around your patent? Now ask yourself, can your claims block those moves? This is where many founders worry that their claims might be too narrow. But here's the truth. A narrow claim isn't a weak claim. If it protects the version your customers are actually buying. So your goal with product patenting is this. Describe the benefits of your product broadly enough that competitors can't make a few tweaks and get around it, while still staying close to what delivers your unique value. Smart product patents don't try to protect the whole world. They protect what works, what sells, and what differentiates you. Moving now to the types of U.S. utility patent filings, let's talk about provisional patent applications, one of the most powerful tools in a startup's IP toolbox. Think of a provisional application as a placeholder. It lets you lock in your filing date for an invention without needing to submit a full utility patent just yet. That early date is critical. It secures your position in line while you're still developing your product, raising funding, or testing the market. A provisional isn't examined by the U.S. Patent Office, and it doesn't become a patent on its own, but it gives you 12 months to file a full utility application that claims the benefit of that early filing date. Now, here's the important part. Your provisional application is only valid for what's actually contained in it. So while it provides more flexibility than a utility patent application filing, it still needs to be detailed and well thought out. Just because a provisional is a placeholder, this doesn't mean you can be vague or non-specific when you are writing it. Use your provisional application to capture your current tech and product concepts in as full of a form as you know them today, and include examples, variations, or even future use cases if you can. That way, you're giving yourself room to grow while still protecting what you've already come up with. Many smart startups use provisional applications to buy time strategically to conduct robust customer discovery, pitch to investors, or prior to collaborating with other companies. These insights can be put into the utility application that claims priority to the provisional to make it stronger and more likely to issue. So if you're not quite ready for a full patent application, but you need to protect what you have done so far, filing a solid provisional patent application might be your best next step. Now let's talk about the U.S. utility patent application process. Unlike a provisional, a utility application is a full, formal filing. In other words, this is the real deal. It includes your invention specification, drawings, examples, and claims, and it gets examined in the U.S. Patent Office. Once approved, it becomes an issued patent that can protect your invention for up to 20 years from your earliest utility filing date, as long as you keep up with the required maintenance fees. You can file a utility application in two ways. You can file it on its own and get a priority date for the utility, or you can file it within 12 months of a provisional application and claim that earlier priority date. Now, here's what matters most. If you want broad protection, your utility application needs to be comprehensive. That means clearly explaining how the invention works, how it's used, and all the possible variations or future applications. Why? Because you can only claim what you've disclosed. If you didn't include it in the application, it's not protected. And this is where many startups fall short. They underdescribe their invention and end up with narrow claims that are easy for competitors to work around. So when you're preparing a utility filing, think long-term. Think about your business model, your roadmap, and how your tech and products might evolve or scale. The more strategically you disclose your likely innovation roadmap now, the more flexibility and protection you'll have later. A well-crafted utility patent doesn't just protect your product, it protects your position in the market. Even if your technology is new and solves a real problem, some things just aren't patentable under U.S. law. The patent system draws the line between ideas and implementable innovations. Here are the most common categories of things you can't patent. First, simple automation. Replacing a manual task with a digital one, like turning a paper form into an app, isn't enough. Your automation must create a new technical outcome, not just speed up an old process. Second, pure math. Formulas and equations are considered abstract ideas. You can't patent math itself, but you can patent a specific system that applies it in a new technical way. Third, products of nature. Natural things like minerals, plants, or DNA sequences can't be patented. But if you modify them to solve a problem in a novel way, that might be patentable. Fourth, abstract algorithms. Algorithms alone aren't patentable unless they're tied to a technical result. It's not what the code does, it's what outcome it creates. Fifth, processes with no outcome. Your process must produce a clear, practical result. Using AI to process data is too vague. Using AI to predict in-store foot traffic is more specific and potentially patentable. Your quick takeaway: to be patentable, your idea must deliver a functional, real-world result. If you're unsure, work with an IP advisor to shape the story around your innovation and make it more likely to avoid refusal on these grounds. Now let's explore how to build strong patent applications that reflect your real value. First, let's frame the two classes of patent applications that I most often see startups filing. Platform innovation patent filings are typically not just one-and-done inventions. Rather, they lay down enablement of disruptive technology that could be relevant to multiple business models by serving as a foundation for more than one product type. Platform innovation patent applications are usually part of a larger portfolio strategy for a startup. Because platform technology can lead to many use cases or spin-off products, you'll need a much broader disclosure in your patent application. This helps support multiple claim types and even multiple filings over time from the same patent application. But it doesn't stop with what you are planning to deliver to customers now and in the foreseeable future. You also need to think beyond the product and consider second and third order market effects. Ask yourself, what happens when customers no longer have the problem you're solving? How does their behavior change? What new needs or markets emerge? And how will customers respond to your platform once it's in the wild? Could it unlock entirely new business models or partners? This is the heart of platform innovation patenting. You're not just protecting what your tech does today, you're future-proofing all the customer value propositions that your innovation enables. Now let's look at product innovations as a second common startup patent filing category. These are typically focused on a single specific product rather than a broad platform. To file a strong patent here, you'll need a deep understanding of the prior art. In other words, what already exists in the market and why your solution is an improvement. You'll want to clearly describe how your product is better and why. That includes pointing out the gaps in previous solutions and showing how your product fills them. Also, be strategic about design arounds. Think ahead. How might a competitor tweak your product to avoid infringement? Your claims should aim to block those paths. It's also totally fine to pursue what's called a narrow claim, especially if it covers your best commercial version. In fact, narrow claims aren't really narrow if they protect your core product in a way that prevents easy knockoffs. The goal is to describe the product's benefits broadly enough that competitors can't make a few small changes and still compete with you. To create strong patent protection, startup innovator teams must spend the time needed for their patent team to not only understand their company's tech and products, they also must provide customer context and description of the various value propositions that will set up the content of the patent applications. Of course, a patent application has to include a just the facts technical explanation of the invention that is being claimed. But if you only include this, you are setting yourself up for a challenging examination process. Think about it. Everything looks obvious in hindsight. To counter this likely assumption by a patent examiner, you should highlight why the subject matter you are seeking to patent was not easy to develop. First, record the pain points and the light bulb moments. When did things break, stall, or suddenly click? Drop screenshots, bench notes, and Slack snippets into a shared folder. These details prove real-world problem solving and often reveal the feature will anchor in claims. Next, explain why it was hard in real time. What looked simple on a whiteboard but failed at scale, cost, or otherwise? Put numbers around it. Tolerances, thresholds, ranges. That's gold for enablement and helps us set claim boundaries competitors can't tiptoe around. Then, tell me what surprised your technical experts. These include unexpected results, counterintuitive parameter windows, things the datasheet said wouldn't work. This tells a powerful, non-obviousness story that examiners and judges actually understand. Now, provide examples aligned with the scope we want. Show at least one best mode, plus variants, alternative materials, control algorithms, architectures, and manufacturing paths. Call out what's required versus optional. Those variants become dependent claims we can deploy later. Ask, what other problems can this solve? Map the same mechanism to adjacent use cases or verticals. That's how we justify broader functional language and keep the claim family useful as the product evolves. Finally, what business models can this enable? Usage-based pricing, platform licensing, APIs, or consumables. We'll translate that into system, method, and computer-readable media claims so the patent protects how you actually make money. It might surprise you that I often find my conversations with the business team the most valuable aspect of creating strong patent rights for my startup clients. I want your customer discovery notes, pitch decks, and competitive analyses. These sources tell the story of the unmet need, who's struggling, what they tried, why it failed, and the value of your solution in plain business terms. That story is what convinces an examiner that this isn't just another feature, it's a real market win. Give me the narrative you use with investors, the pain, the promised outcome, and the proof. Pilots, KPIs, win-loss notes, even quotes from customers. We'll translate that into claim language that protects the benefit, not just the parts. Next, think about pivots and adjacencies. If the same mechanism could serve a different segment, pricing tier, or delivery model, say so. We'll map those adjacencies into dependent claims and follow-on filings so competitors can't sidestep you by switching verticals. Your innovation and business roadmaps are gold, real or hypothetical. Show what ships next quarter and what's on the horizon. We'll disclose variants and future embodiments now so we can claim broadly and keep doors open as you scale. Bottom line, the best patent protection starts with the customer. Don't leave the business team out of the filing. Bring your non-technical insights to the table, and I'll work to turn them into claims that protect how you create and capture value. We've reached the end of this Startup Patent Bootcamp. Thanks so much for watching. If this helped you think differently about patents, tap subscribe and turn on notifications so you don't miss what's next. If you're ready for hands-on help, reach out to me on LinkedIn or via email to see if it might make sense for us to work together. I appreciate your being here. Keep building, keep learning, and make winning with patents a goal for your startup.